Common mistakes people make when trying to understand the law. Number 1, lots of people think that common law and legislation are completely separate and have nothing to do with one another, and that perhaps you can stand under one or the other, such as the phrase standing under common law, and thus trying to say that legislation doesn't apply. This is simply a misunderstanding, because common law is in fact a collection of decisions made by judges when interpreting the law when presented with any given set of facts. The common law then interprets that law and how it should apply thereforward, hence creating a precedent. And there is a hierarchy of these decisions, obviously with the Supreme Court being binding on every court below it, and so on. Number 2, people often refer to old Acts of Parliament that have been repealed or amended, but they refer to them either in their original enacted state, which no longer applies, or to their original state, which has been since amended. This is why it is always important to ensure that you are referring to up-to-date and accurate law. Number 3, sticking with Acts of Parliament, many people think that Acts of Parliament are only civil and have no bearing on criminal responsibility whatsoever. But that's not true either, because many acts will have a lot of civil application and create 1 or 2 offences along the way. The next common misunderstanding is a popular one in the comments, because Acts of Parliament usually refer to he rather than he or she. This is merely a simplification. It doesn't mean that the law only applies to men, it applies to everybody. The next misunderstanding is a combination of Acts of Parliament and common law. Very often people will look at the Act of Parliament, read it literally, but not have any of the application from common law, which is, as I said, decisions made by judges, and thus lack the correct interpretation of that law given a set of facts, and thus misunderstand how the law will apply in a particular scenario. Next, people very often think that everything must come under some kind of contract to be valid and legally binding. This is not true either. The law of contract is very broad, and people and companies are free to contract with each other in virtually any way they like, so long as it's legal. And there's a significant body of law, both in statute and in common law, that will determine whether the terms of this contract are enforceable and how those terms are to be interpreted. But many duties, responsibilities, taxes, and so on arise out of statute, not out of contract. So by way of example, just because there is no contract between you and your local authority, for example for council tax, doesn't mean that you don't have to pay it. There doesn't have to be a contract in place for you to have to pay that tax. Another misunderstanding arises from the notion of the consent to be governed, which is a philosophical notion from many, many years ago, but it doesn't mean that each individual must consent to these Acts of Parliament to apply to them in order that they do apply. So in short form, your consent is not required. Back to the subject of contract law, many people think that a contract is not legally binding unless it is physically signed in wet ink with a pen. This is not true either. Contracts can arise simply out of conduct when nothing was written down at all, much less signed, much less with a wet ink signature. Speaking of wet ink signatures, some people think that summonses and writs of control, warrants of control, search warrants, and many other things are not valid without a wet ink signature in the name of a particular judge. But again, this is not true either. There is a court in West London which is pretty much dedicated to the issue of warrants, which are practically all done electronically with no signature at all. But that doesn't make them any less valid. On the issue of warrants and summonses and things like that, many people seem to think that if it's not sent out to you by the court, then it's not valid. But again, that's not true either. Sometimes it might be printed by a local authority, but because it's been issued or authorised by a court, it is still very much valid. These are just a few that have come up in the last few days. There must be many more, so do comment down below if you think I've missed something out, and I'll come back to that. But in the meantime, thank you for watching.